And as you just heard, the minister with that portfolio for economic growth and job creation, Darrell Vaz, confirmed that the land is needed for the redevelopment of Port Royal. To another story now, there are renewed calls for the government to urgently make legislative changes to protect minors from being imprisoned for non-criminal offenses. It comes from human rights lobby group Jamaicans for Justice, JFJ.
Prison time for no crime. That's the headline from the Sunday Gleaner and an indicator of the JFJ's new advocacy focus. At a press briefing on Monday, the lobby group highlighted that new cases of children being committed to the custody of the Department of Correctional Services for the non-criminal offense of uncontrollable behavior has warranted the renewed concern. JFJ Executive Director Roger Malcolm noted that in criminal cases, including murder cases, the accused is allowed to enter a plea, have legal counsel, and offer evidence in his or her defense.
And only after that process is completed are we able to send criminals to jail. When it comes to children under Section 24, we have been aware of girls who have come before the court in the morning and been sentenced to a 3-year sentence at a correctional center by the afternoon, with little or no ability to even speak.
JFJ attorney Monique Long says based on investigations, there is concern for the hundreds of children who remain locked away despite having committed no criminal offense.
For the girls we have come in contact with and for all the children who are currently incarcerated on this basis, it's very clear that there is a breach to their human rights. A number of things arise in the court processes, a number of things arise in the quality of care they're being afforded in these settings that have raised significant red flags for us and that have brought us here today to speak to you about the issue, but to ensure that we're actively on the ground trying to do advocacy and legal work to ensure that these girls are freed.
This advocacy is not new. Mr. Malcolm notes that previous efforts have resulted in successive governments promising to amend the Child Care and Protection Act to remove the possibility of incarceration for behavioral difficulties. This dates as far back as 2013.
In that same year, the then Minister of Youth announced that the government would be taking legislative action aimed at, quote, removing the so-called uncontrollable behavior label from some children and, quote, removing the option for judges to commit children displaying antisocial behavior to correctional centers. Well, unsurprisingly, we know that those amendments never occurred, though the public thought that they did.
A similar promise was made in June 2015, and after the change of government, again in 2016 and 2018. The JFJ executive has reportedly met with the leadership of the Justice Ministry, including Justice Minister Delroy Chuck and the Permanent Secretary. Mr. Malcolm says a commitment has been given that legislation will be brought to Cabinet to effect the change.
We've heard those commitments before, and those commitments have been made in the most formal of terms before. And so until implemented, we will have to continue our advocacy to have this law repealed and appropriate therapeutic alternatives instituted.